I was in Bill's very last class that he taught as a full-time member of the Stanford faculty. And I still remember what he said to the class that morning. He kind of paused and looked down and said, "Class, I got up this morning and turned to my wife and I said, I don't know what I'm going to say this morning." And my wife said to me the exact same thing she said to me on my very first day of teaching, which was, "I'm sure you'll think of something." And boy, was that true.
Even in his classes, what really struck me as something different about Professor Gould was the way he would understand the importance of the cases to people. There are a lot of different teaching styles. Uh, Professors love to talk about hypotheticals and go on from one case to the next case to the next case. But with Bill Gould, it was always about understanding the impact of labor law cases on people. And it was not a matter of saying, well, he's for the workers and he's against business. It was that he understood and he could speak with great clarity and great consistency and just great authenticity. Things like donning and doffing rules in labor. He knew what they were. He had been active with the UAW. He'd been active as a labor lawyer. He brought that into the classroom. And later on, when I became dean of a law school, I looked to that. I looked to the genuineness of law professors' experiences. It's one thing to come from a top school, be editor in chief of the Law Review, go off to be clerking and multiple clerkships, and then come in to teach. It's another thing the way Bill Gould did it, which was through practicing critically important areas in the 60s and in labor law, and then going into becoming a law professor. But he really brought that experience into the classroom. He not only just making it more lively, but also bringing the authenticity of having represented individuals, having presented cases before the boards on labor law, and that made a real difference to my understanding of the law and what the kind of lawyer that I wanted to be.
I was actually thinking about an experience that I had as a student of Bill's teaching excellence in this conversation, which is we had, Stanford has students who are, contrarians for the sake of being contrarians. And there was one of those in the labor law class that I took with Bill, and he was teaching a case that the name is escaping me now, but it was a Supreme Court case involving unreasonably dangerous conditions for workers. And one of the students said something about how, is it really good use of the Supreme Court's resources to, adjudicate this like individual worker safety issue? Is it outrageous question, in my opinion? And I could see Professor Gould's demeanor change. I thought I was, he kind of like puffed up a little bit and walked a little closer to the student. And I was like, oh, geez, what's about to happen? But he really just very skillfully, using the Socratic method, asked some questions back to the student and had a discussion with the student that like teased out the issues. And I don't know what the student's conclusion was at the end of that, but I think for me watching, it was a very impressive way to handle somebody who obviously thought very differently than I did and thought very differently than Bill Gould did about the importance of workers and their lives and their safety and their experience at work. And that, these are the very issues that the courts, including the Supreme Court, should be spending their time on. And he was able to do that in a way that was not, that was neutral, that was had integrity, had intellectual integrity, had an educational value to it, and was a very skilled demonstration of very skilled teaching in what I thought were kind of pretty difficult circumstances with the students in the class.
I'm Scott Whitland. I'm class of 1988 from the law school. I'm a partner practicing labor and employment law at Barnes and Thornburg here in Los Angeles. And I was a student of Bill's in '86 I remember it distinctly for reasons that'll become obvious. And 87 and I think in the fall and the spring of 87 and the spring of 88. And I was Bill's research assistant in 1986 and 87.
I mean, he was always so approachable, both during and after class. He was never a teacher who, wanted to humiliate the students, through the Socratic method or anything else. He, at least for me, and I think it was true of my colleagues, you wanted to participate in his class because he brought such enthusiasm, such intellect to it. And he always was able to turn something into a teachable moment. I mean, of course, there were students who hadn't done their reading or hadn't been adequately prepared. But again, he wouldn't humiliate them. He would turn it into a teachable moment. He would find a way to draw that student into the discussion in class. And I just thought, again, that was just remarkable because I think we've all had our share of, the humiliating type of professors, not just in law school, but as undergraduate. And, that warmth and that approachability, I think was also a part of, developing my interest. I said, if this is the kind of person who's not only a labor law professor, but a practitioner. I mean, he practiced law with UAW here in Michigan and otherwise, even before he became a professor. If that's the kind of person who wants to be a labor lawyer and is a labor lawyer, that's the kind of person I want to be.
And
How big were his?
I would draw folks out, not in a humiliating or degrading fashion, but he was just terrific at that. And I think that, increased the popularity of his course. And it meant he was approachable. You didn't feel scared to go to his office. As intimidated as the stacks were, he was not intimidating. And it was always a wonderful experience to go see him after class. One of the reasons I went to Stanford, as opposed to Harvard Law School or other schools, was that I thought in a smaller environment like that with people like Bill, from what I knew about him, even before I met him, it would be a more enjoyable environment as a student. And I generally found that even the toughest professors weren't interested in humiliating the students. Professor Kaplan was great. And there are a lot of other professors like that too. But again, my experience in law school was far better than, you see in the crazy movies like The Paper Chase, right? with a Professor Canfield and all that kind of stuff. And Bill really epitomized that kind of humane teaching method, which again, positively affected me for the rest of my life.
I think what the way that Bill is described, and I never took his course because we were there before him, but I would agree that how you describe Bill, I'm not sure how successful I was, but that's what I strive towards. When I asked you about small classes, I mean, all of my classes I never had a class more than about 20, I think, at Stanford, because they were all elective courses based on what I'd been doing in the government. But I also found that if you had a class that was 15, 20 people, that you could, I think Bill just naturally did it that way, but I think smaller classes did lead to that, as opposed, from what I hear about lectures at places like Harvard Law School with 300 people there.
Yeah, I had Bill, in two different kinds of environments. I had the introductory labor law class, and when I took it in '86, I remember it as being bigger than 30. I think it was about 50 or so people. It was also at 8:30 or 8:40 in the morning. I'm not exactly sure why it was so early, but I distinctly have the recollection of one of my roommates, former roommates, coming into class, and I could always tell if he had just rolled out of bed because it was, he would be in a baseball cap and sweats, and I could say, "Oh, Kevin didn't have time to take a shower this morning before Bill's class." But in those classes, Bill would lecture, and he may have had notes, but he would apparently lecture extemporaneously. He'd walk away from the podium and lecture extemporaneously, and he'd be talking about something, and then all of a sudden, in the middle of his lecture, he would go footnote. And then he would go literally dropping as if, having read his, rough drafts of his manuscript, literally as if it were a manuscript. And then he discussed the footnote and then return back to the middle of his argument or middle of his lecture topic. I'd never seen it done before. I've never seen it done since. But, that's Bill's encyclopedic knowledge.
We've heard a lot about Bill in the small classes, and how wonderful he was in that context. You were talking about a larger class of 50 or 60, and you talked about what a great, how great he was as a lecturer. How did he draw people in to make the class seem like, did it seem like it was a smaller class than a class of 60 people?
My recollection is he would lecture and then he would raise issues and he'd ask questions and I don't remember anybody being Socratic at Stanford when I was there. By the time we got there, people thought that was just inhumane and had adopted asking questions and just, but not really in a Socratic method. And nobody got called on. I don't remember anybody getting called on at Stanford, sort of, out of the blue. Mr. Whitland, tell us about this case. And whether or not we were better for it or worse for it, you could make arguments. But Bill would talk about issues. I remember him talking about the Jacksonville freight case, and which is a boycott case where the issue was, was it a prohibited secondary boycott because the workers were boycotting. I think they were Russian ships at the time because they were really engaged in a political protest and not really a strike, and discussing the merits of that. So I remember, him asking about things and drawing people out. I will say this, it was not my best grade in law school, which, may be surprising. And Bill would probably say I didn't learn anything in his class because I represent management in labor relations.
Oh.
But, Bill will also tell everyone that he is a neutral, and, he's lived that life. He's been an arbitrator, headed the National Labor Relations Board, headed the California Agricultural Labor Relations Board, and really, sees work as in a fascinating field of both life and academic endeavor.
So I'm Chris Hu. I'm an associate at Horvitz and Levy, which is an appellate law firm in California. I graduated from Stanford in 2013, and I know Bill because I worked as a research assistant for him for about 1.5 years, and I also took his labor law class. So one funny thing I was thinking about is that in addition to being his research assistant, while I was his research assistant, I took his labor law class, and he used me as a sort of unofficial teaching assistant for the class. So while I was enrolled in the class, he was also asking me to continually update the syllabus with new decisions as they were coming out. And so I was sort of playing dual roles in the class, which was funny.
Yeah.
When I came in for my interview for the teaching, the research assistant job, I of course knew who he was. I had read his book, the primer on labor law, that past summer because I had been working at a union side labor firm. So I saw the job announcement for the research assistant position. I was really excited to apply. But when I walked into his office, I really didn't know what to expect. I'd never met him before. Took me a little while to find his office. And then when I walked in, I wasn't sure. Initially, I wasn't sure I was in the right place. It was, there was a lot going on in the office, books everywhere, papers everywhere. And then I walked in and met him, and it was just the start of a really wonderful experience. I worked on an update to his book, and I helped him reading and summarizing new labor law opinions as they came out. But more than anything, I just came I had appointments with him every week, and I would go in, and sometimes he didn't have a formal project for me. Sometimes it was just an opportunity for us to spend time talking, whether it was about his work on the NLRB or about our shared interest in sports, or really about anything. And so it was a job, but it really turned into a personal relationship as well. I felt really privileged to work for him, but he's such a warm person. He didn't make it seem that way. Like, he made it seem like we really, he was my boss, but he didn't, it's not as if he has a big ego. It's not as if he was always talking about, oh, I used to be on the National Labor Relations Board. He's a very modest person. And so, I was odd to be, in his presence, but he's very down to earth and very humble person. So, it made it easier for me to get to know him, even though he was much more senior than me and much more accomplished than me. As a student, I don't know whether I've ever would have thought to think of myself as really his colleague, but I think in practice, we sort of became collaborators. So we were working on updates to one of his books, and we were really working on it together. So a new opinion would come out that he'd want to work into his book, and he would ask me for my opinion. He didn't just treat me as someone who was gonna, take what he told me and write it up. He wanted to know what I thought. We were at that time, there was a lot of interest in sort of the interaction between traditional labor law and social media, which was new at that time. So whether it could be protected activity to post on Facebook about your conditions of employment. And, naturally, he was very interested in what I thought about social media and how it might interact with traditional labor law principles. And then for the NLRB opinions, from the 90s that we were discussing, many of which were really important to the topic, were ones that he had personally participated on, or even, and so I personally had a personal interest in labor law, so I was just inherently interested in the topic, but he really made it come alive because he had lived through all of it.
And I think that you said that during the words you used when you were talking about his teaching, you said he was a whirlwind of ideas.
Definitely.
And you learned that, yeah. What?
Yeah, I think whirlwind of ideas is a great phrase to describe him, in part because he wasn't someone who taught labor law as a static subject where all these principles were settled and there was nothing new happening. Every day there are new opinions coming out, and he would always be changing the syllabus, wanting to work in new material, because he, I think, correctly saw labor law as a dynamic field that's always changing. And not only was he a whirlwind in the classroom, he was a whirlwind in what the syllabus contained. So as the law changed, he wanted to change what he was teaching too, and that made it really exciting.